most likely that best interest would be to less time with that parent.
Realistically, that is not their job.
All that money goes to the lawyers, unfortunately.
So does that result in, or potentially could that result in supervised visits?
I'm not going to counseling. I don't have a drinking problem. I'm not doing this.
And you end up with a client who's like, Matt, I'm not doing any of this stuff you're telling me. Matt, welcome back.
Hey, thanks for having me back. I was worried it would be a one and done thing, but here we are. Yeah.
How's Stampede?
That was good. Yeah, we just did the whoop up, and then I think that was about it for me. You?
Yeah, Stampede's always a great time. But I presume that Stampede is a time of the year that perhaps afterwards you see a little bit of an uptick in family law disputes, shall we say.
Yeah, there's a lot of phone calls and consults coming in after Stampede. First couple of weeks, we get quite busy.
Yeah.
It's crazy. One of my first memories moving to Calgary for law school was there used to be like Stampede related advertising. And I don't really remember who did it, but there was like a billboard that was like, it's still cheating if it's stampeding or something like that. And it was like such an eye-opening thing for me. I was like, oh, people are they really lean into it in this particular city. So I imagine it's a busy time.
Yeah, we were on our sleeve. So I want to talk about poor parenting decisions.
Okay.
You and I both have kids. Hindsight's always 2020,
Yeah.
right? So over the years, you look back and you think, yeah, I probably shouldn't have done this or that, whatever it might be. And I have 4 kids. My oldest is 17. My youngest is 3. And we've totally changed our parenting approach with our youngest 2, just based on how we raised our oldest 2, right? And so, much to the chagrin of my 2 older ones. But in any case, that's just kind of how it is with parenting. But what role does poor parenting, or do poor parenting decisions play in the context of family law, specifically, let's say, with parenting?
Yeah, I mean, we talked last time a little bit about the best interests of the children, right? And that's how that analysis always starts. It's from their focus. The phrase is good enough parenting, and it's a pretty low bar in most cases. If there is like a pattern of poor decisions and that kind of stuff, then most likely that best interest would be to less time with that parent. If they're putting the kids in risky situations and doing that type of thing, then the courts will probably think, all right, well, has some issues making decisions when he's parenting, or she has terrible decisions when parenting, so we're going to limit how much time that the children are going to be with that parent until they can work on that. Nice thing about you who are still together is that you've seen that there's changes and you can learn from what you've done wrong. When you're in a separated family, everybody kind of forgets that. And so when you have 2 people that are together, if the kid's doing something and more on the risky side, for example, like one of the parents let them climb across the top of the monkey bars, probably not a big issue when you're together. When you start separating and you're fighting about every little thing, then one of the parents is always picking those issues and trying to use them as well.
Like they become like little weapons and little pieces of evidence to support your case
exactly.
Instead of a learning experience.
Yeah, and had you been together still, wouldn't have been an issue, but because you're not, now it is an issue. And it's also when the courts can get involved and start second guessing whether that was a good decision or not. But they don't typically like to get into that minutia of all that unless there are some serious risks to the kids, like driving without seat belts or taking them on motorcycles without helmets and those types of those big decisions.
Mm-hmm. So would you say that, have the courts somewhat criminalized poor parenting decisions, or do you not see it that way?
I don't know if I would say it's criminalized so much. I think if you're willing to change and work on that, and you're able to show that you're willing to do that, then it shouldn't be a big issue. If you take the view of, I know best, they're my kids and I'll do what I want with them, then, and you should continue to show that pattern, then that'll be used more strongly against you.
I might say that poor parenting decisions perhaps can in some ways be in the best interest of the children, because it raises them a particular way, and perhaps they can become more productive adults because of that. Now, of course, there's a limit to everything.
Yeah.
But just something, what you said, climbing on top of the monkey bars as opposed to hanging off of them,
Yeah.
right? Maybe that somehow helps that child grow
Yeah, I
up.
mean, it's a risky situation, but it's a risk that they took. And instead of like instilling fear in them, telling them you can't do that, they made it across safely. Things are fine. Next time they're going to climb a ridge, like
Yeah.
your kids do with you all the time. So I think it's like, yeah, it's sometimes those decisions, if they're really risky, they can be used. But if things go smoothly, they also, help your kid develop and
Yeah.
gain some independence and things like that. But it's a line, right? I think that's
That is what it is, and the courts try to do their best to analyze that, whether there is some actual harm that could be done. Because yeah, I mean, letting your kid crawl across something they shouldn't be crawling across and they fall and break their leg,
that's harm.
that's
Yeah.
harm, but it's also a life lesson, right? So yeah, well, now you shouldn't have been doing that. Or if fall and hit their head on something and like, okay, well, I shouldn't have done that. Maybe they shouldn't have put that fork into the outlet or something like that. They learn pretty quick.
Yeah,
But if you try to baby them all the way through, you're right. There might be some risk to them down the road about not having those life lessons.
So does that result in, or potentially could that result in supervised visits?
Supervised visits are kind of the de minimis of what the court can get down to. So that in some of their views, that's the bottom. Like we're talking about some serious harm to these kids, and they need to be watched while they're with the kids.
I see.
Serious alcohol or assault stuff or harm that can happen.
And
to the kids.
substantiated alcohol abuse,
yeah.
not a mere allegation,
That's
right?
Yeah.
Well, it's not always that. I mean, it's. I interesting when you say that, because there are situations that I've seen where people have been, often men. I'm not in any way suggesting that women aren't vulnerable in domestic relationships or things like that. But generally speaking, the people who are charged tend to be men, and there have been instances where they are allegations. There's allegations of severe alcohol abuse or violence, not even towards the child necessarily, but violence between the partners, that has led to just blanket no contacts. Definitely, because it's not the minimus. The expectation in criminal is no contact, and then you slowly work contact up. And so that trumps any ruling that you'd get from family court. Obviously, they have to comply with the one or the other. And then sometimes when it goes back to family court, my understanding, obviously, Matt, correct me if I'm wrong, is by the time you get to supervised visits, it's incredibly difficult to work your way out of supervised visits. Is that fair?
You do have to be doing everything right? So that's kind of what you said, is everything is reviewable, and parenting time and access schedules is always reviewable on a material change in circumstances. Generally, when there's the supervised visits that are put in place, they'll say for 3 or 4 months or 6 months, and then you can come back and have that reviewed. And so then if all the supervised visits and reports are glowing, and you've got, if it's alcohol, for example, you've got a bunch of breathalyzer results saying you're not drinking and all that kind of stuff, they will then drop the supervision and start increasing it.
And when you say supervised access here, or supervised visits here, it's professionally supervised. Somebody has to pay for it at a facility or at a location?
It depends, like everything else. But generally there's professional ones that you can hire, then they come and they will write reports. Or if everybody's agreeable, they can be other family or friends that can be trusted by both sides. So in a lot of cases, like the maternal or paternal grandparents are still friendly with the other party, and they would be agreeable to them being the supervisor, and that kind of stuff. Or an aunt or an uncle that still has a good relationship with both parties, or a mutual friend. If there's no one like that, then it's got to be a professional. Or if it's serious allegations of something, then usually you want that professional there.
So from like an advice point of view, I've had clients, not clients of my own, because generally I try to send them to a lawyer that I trust to get like sound advice. His name may or may not be Matt. You can skip him over there. But definitely I've had individuals as a Crown prosecutor, and just seen people in court who, because they are so desperate to make sure that they have access to their kids, they agree to supervised access. Just because it's the fastest thing, it's the only thing the other party's going to agree to, and they think some access is better than no access. And, from a family lawyer's perspective, is it always better to have some access versus no access if it is supervised access, if it's so hard to get out of there? Because you know, criminal law, I mean, everything's an admission. Every time you do anything, I'm like, am I admitting something here? And so to me, when I look at that decision, it's like you are almost admitting that it's necessary if you immediately agree to it. That could be very adversarial, and I understand that. But from your perspective, from your experience, is it best to just agree and work your way up, or is it better to take the extra 2, 3, 4 weeks it takes to actually run it through the court system and present your side, negotiate, as opposed to just taking what you can right away?
Take what you can right away is my view. My opinion on that is you get in as soon as you can to continue building that relationship. So if all you can get from the other side is supervised access, and it's going to take you a month or 2 months to get into morning chambers, get that supervised access. Because when you get to court in 2 months, they still have those allegations coming at you. The court might just be like, all right, we'll start the supervised access now. But if you take it now and you start doing that and you build it up, when you get to court at that point, you can be like, I've had supervised access for the last 2 months and there's been no issues. And the court's like, yeah, you're right, you haven't. So we're going to go to unsupervised.
So in your experience, the courts haven't treated it as an admission of guilt, if you will, or an admission of necessity.
No, interim orders are just that. They're interim. They're like I mentioned before, they're kind of band-aid solutions to deal with what we're dealing with right now. Family law is weird in that aspect, is because, you know, if it was a civil matter or you're suing a construction company or something, everything can wait until it gets heard.
Yeah.
But you can't do that
With kids that are growing,
right? So you have to have something in place to build that up. And as a person who has the allegations against you, I actually kind of like having something put forward in there so that I know what my client has to do to jump those hurdles to move forward. So
you have a target you can see that way.
And it's also good on that sense too, if you're having those allegations thrown at you, is that if you're jumping all those hurdles and then new ones just keep coming out, the court's going to see it the other way. They're gonna look at the other side and be like, okay, they're the difficult parent throwing all this stuff continuously at him, and he's doing everything he can. Maybe we should be giving more parenting time to, in this case, him. That's just what I said, but it goes both ways.
Of course.
Yeah. For moving forward, right? And then, because one of the factors is under the Family Law Act and under the Divorce Act is kind of what's been called that friendly parent principle, is who's more willing to facilitate that parenting time. So
yeah, like who's more willing to be cooperative, neutral.
Yeah, and if this person is taking what they can get to have whatever relationship with the kids they can, and doing all these things to calm the other side down about their concerns, and like, look, I did anger management. Look, I did some alcohol and drug courses, and I did this and I did that. Then they still just like, well, now there's this, now there's this, now there's this. The court's gonna be like, okay, obviously we see the problem now, and if you start doing that right away, you might even get to that point by that first appearance.
Yeah, so all of that can be an incredibly maddening process for a client,
yeah.
right?
Yeah.
Extremely frustrating. If you have somebody who isn't an alcoholic or isn't abusive, but you have those allegations lobbed at you, how do you counsel clients to take the high road?
You're not going to remember.
I'd be so bad.
Your kids are, if you have young kids, they're not going to remember what's happening at this time when they grow up in 5 or 10 years. You might remember you missed this time, but you won't think about it that much. They will remember the ongoing conflict and the stress that you put them under, and what they've dealt with, and they will remember, all the stuff that happens between their parents and how much they fight. They will not remember a day or a weekend they didn't get to see one of the parents back and forth. So don't focus on that. Focus on the long road of these kids' lives, taking out that toxic stress and moving forward in their best interest. And that's what I usually say.
From a family law perspective, I mean, obviously a lot of what we've been discussing has dealt with access to children, and even your answer there went to your ask, how do you counsel them? How do you balance that when there's also the fight about the assets, about the house, about everything else? Like how do you advise them on what's worth being really litigious about, so that it doesn't look like they were willing to fold their tent on their kids, but it was really important that they got their truck? Do you know what I mean?
Yeah. Well, with any decision, honestly, what I tell a lot of my clients through it is, you can pay this money for your kids and give it to her to take, if I'm representing the man, and vice versa. If it's the wife, like, you can take less and he gets to keep it and you put it towards your kids, or you can pay it to me for mine. So you get to pick where that money goes. Happy to take it, and we'll keep fighting about it. Or we can come up with some resolution where you get to keep more of it in your pocket, and you can move forward and have that used for your own kids.
So just a really practical approach, yeah.
Yeah.
So do you find yourself playing part psychologist as well? Is that how you
Yeah.
feel that way?
Yeah. Yeah, there's too much emotion in what everybody's dealing with. I recommend anybody that's going through any separation, whether it's high conflict or not, to get counseling and see someone and deal with what you're dealing with. But yeah, there is a lot of that. And if there isn't some serious allegations, or even with what am I talking about? If there is serious allegations, mediation, arbitration is a much better place to go and try to deal with moving forward.
Because you didn't start in mediation arbitration. You started predominantly in you started in personal injury.
That's right, yeah.
And then you kind of migrated pretty early on in your career to family. But you have recently, in like the past, I'm going to say 3-4 years, really focused in on the mediation and arbitration. Is that fair?
Yep.
And that required you to take some courses or some certifications?
Yeah, so I've done a lot of, I did the 40-hour mediation training course. That's the one that lets you be a mediator in Alberta through the Alberta Family Mediation Society. Great course, really interesting. And then I've taken a bunch of other little courses on arbitration and mediation and other things throughout then. And just been conducting, going to mediations, taking my clients to mediations, conducting mediations and arbitrations, and learning that quite a bit. But that history of being in court, specifically because most of my practice was high conflict parenting, is seeing that the courts are not the place to deal with family law matters. They're in my opinion, they're just they don't have the resources, unfortunately, and it's too much for the justices to handle everybody's. And there's other ways that are better that you can have it dealt with.
So you kind of answered it, but in your experience from dealing with the high conflict litigation and getting, presumably decisions that went both ways coming down from the justices versus, your role in lawyer assisted mediation or acting as a mediator yourself.
Yeah.
Have you seen examples where there's been this high conflict case, they've managed to move it into arbitration and they've left feeling acknowledged, feeling satisfied with the situation?
Absolutely.
Yeah.
Few. Yeah. Mostly because there is a lot of good mediators out there, and it's not a mediation. I can talk a little bit, but it's not a normal mediation like you would go into a car dealership and try to negotiate buying a new car.
Right.
You really focus on the interests that everybody has, and you build up from there to a resolution that's going to work long term. And so instead of focusing, if you're talking about property, well, the house is worth $850. Well, no, it's only worth $825. Well, if you switch gears and look, okay, who needs what to purchase a new house, or who can keep this house, and what are the actual interests in what we're looking at, and build up to something from there. It's the same with parenting. It's like, what are the concerns everybody has? How can we address those concerns so everybody can work forward? If there is communication issues, well, then you could use apps and other rules to how you conduct yourselves in your communication. You could set in different things on parenting plan. You could go through an extensive parenting plan and have everybody follow that, right? Mm-hmm. You can set all that up. That works for your family, and not something, like I said, a court comes in and decides for you. Because at the end of the day, no one's going to be happy if someone makes a call that they don't like, and a court order is not going to stop a high conflict person from continuing to be high conflict. But if they had a hand in building what you built and had their say in mediation, they're more likely to follow it.
Mm.
So, one of the things that I struggle with is, obviously there's no mediation in criminal law. You either plead guilty or you plead not guilty and hope that you get a sentence that you're looking for if you do decide to resolve.
So that's not the pretrial process, eh? The pretrial conference that you have isn't
so
really akin to mediation?
It is not. So, and to be fair, it's not generally. Particularly in my experience, there are some very knowledgeable, experienced justices in King's Bench, because pretrial conferences are more formalized in King's Bench, where one of the most frequent ones, he's retired now, Justice Wilson. I will remember one of the first pre-trials I ever did on a multi-week trial was with him, and I had a co-counsel, and he looked at my co-counsel and was like, this should be resolved. Like, it could be a trial for this person, but it shouldn't be a trial for this person. And so it was a pretty active discussion between him and counsel about why that matter might resolve. And they try to mediate it. But realistically, that is not their job. So has been some situations where I've had a justice say, if you were able to agree to this plea and this sentence and you put it in front of me, I wouldn't find it unreasonable. Which isn't them telling you to resolve, but it's a pretty clear sign that if I wanted to go back and tell my client, you could resolve this and not go to jail, and if that's what you want, I can do that for you, then that's something that I can do. But generally speaking, it's not something that the judges do. And so the negotiation is between me as the defense counsel, who has a lot of information about my client, and the disclosure from the police, and then the Crown, who, for the most part, unless they have a serious concern about what the evidence is, their starting point is that the complainant is telling the truth and is going to be believed. And so they don't have a lot of wiggle room for resolution, obviously. And the thing about criminal matters is, yeah, if you're charged with an assault, if you're charged with a sexual assault, if you're charged with assault against your kid in particular, you're going to have a criminal record. You're not going to be able to travel, and it's going to be a violent criminal record, so you wouldn't be able to travel to the States easily. You're not going to be able to volunteer with your kids. You're not going to be able to pick them up from school in certain situations, and it is almost certainly going to be used not in your favor. It's going to be used against you when you finally get to family court. And so there isn't really a mediation option, because there's no happy medium often in criminal court. You're either guilty and you have all of those consequences, or you are not guilty and you don't have those consequences. And that's kind of where they're at. So
in family law, it's not a happy medium. A good mediated settlement is one that no one's happy with.
okay.
So it's one that no one's super happy with, but you can live with, right? That's what I tell everybody when
it's
I get
just
into
a
those.
medium.
Yeah.
It's not a happy medium.
If you get everything you want, or you're puking in a bucket, you probably shouldn't have accepted that deal. Either way. Because it's something that's you're going to try and work with, knowing, okay, this isn't the best, but it's better than taking these next steps, right? Because the next steps is where all that money goes to the lawyers, unfortunately. A lot of cases it's necessary, but in most of them, I think you can come up with some resolution outside of that.
So if you have a client who's dealing with criminal charges, whether it's assault against their spouse or like excessive discipline involving the kids, anything like that, if you have a client who has those charges, do you give them different advice with respect to attending mediation or going to court or making these decisions?
Nope. Yeah, like if you got those allegations, advice is the same. Have them dealt with. Do what you're supposed to do. Make sure that you're taking that high road and doing everything. Do not go down the road of trying to flip it and badmouth the other party, because if they've made the allegations first and that's out there, that's all that everybody's going to see, is that you're just trying to deflect, right? And it's a normal strategy of domestic violence people, a Darvo tactic. They try to avoid and blame and all that kind of stuff, and court's kind of really onto that. So you accept your responsibility, not guilt, but saying, okay, that's an issue, I'm going to address it. And that's your best step forward on that.
So have you ever had to deal with clients? Because my advice to my clients, even if they're in family court, is like, you can't admit anything. Don't accept responsibility. Don't use those words anyways. Don't acknowledge that you did these things, because that's all able to come back and seriously damage my ability to defend you from these charges. Particularly, my concern is if I had a client who went somewhere and was told to take the high ground, told to quote unquote accept responsibility, how that would kind of come back and harm them there. So have you ever had to deal with a client who's come to was like, look, my criminal lawyer said, I'm not going to counseling. I don't have a drinking problem. I'm not doing this. Which is advice I've definitely given clients before, because if we're going for a resolution, or I think it's going to help the Crown get me somewhere, then yeah, go to counseling, demonstrate you don't have a problem, take the steps that they're asking you to, because it's not going to take that much time. In a lot of cases, it can be funded counseling, it can be funded steps so that you're not losing money, things like that. But there's also times when I tell my client, I don't want you to do anything that can make it look like you're guilty. I don't want you to do anything that makes it look like you do have a problem.
So with the implied undertaking that typically applies between different levels of court or cases where you can't use information obtained in one case in a different case that doesn't apply in criminal court?
So I think it might actually only apply in criminal case because it's section 5 of the Evidence Act.
Well, it
That's for
applies to
priority.
civil cases too.
But there's
Yeah, I
definitely
think there's
something where
something
you can
for-
say, if you testify under, if you testify under oath in one situation, it can't be used against you if you were not compelled, essentially. But there's been a lot of circumstances where EPO transcripts definitely come up, or disclosed, or used in criminal cases. Family law orders, family law transcripts are brought forward, and they're demonstrated. So it's a very specific rule. And that is why I give my clients those advice, because sometimes they get into family court and they start being like, okay, I admit that this went wrong, and I admit I could have handled this differently, and I admit that, I need to take steps here. And then that comes back to really harm them because they say that in front of the complainant, or they say that in front of somebody who's going to be a witness for the Crown in my case, and they're like, he admitted this in
So
court.
how do you deal with that when you have an aggressive defense lawyer like Caitlin here,
Yeah,
I
guess.
think I'm very reasonable.
and you end up with a client who's like, Matt, I'm not doing any of this stuff you're telling me.
Well, the first thing I would do is probably talk to that defense counsel and just be like, okay, what's the concern here? Because then we're gonna have to change our strategy on my end, because family law side, I want him to start doing this stuff, and just because he's doing it doesn't mean it's a admission of guilt.
Yeah.
But I'm not going to advise him to go do anything that his other lawyer says not to do. But I will, call up his defense lawyer and be like, all right, so what are we doing here? Here's what I was thinking we need to do on the family law side. If he does this, is that okay? Right?
Yeah.
You have your counsel work together on those types of things and making sure everybody's on the same page. Because the last thing I want to be doing if you have criminal charges is stepping on the toes of your criminal lawyer.
It's hard because I think a lot of times, like for sure, I've definitely had clients who want to go to trial. But their number one, the amount of people who come up or come into our office and say, I don't care, I just want to see my kid. And so from a defense lawyer's perspective, I'm like, look, I'm going to do everything I can to help you see your kid, but I don't want to see you convicted. And so it's a lot of it's client management for sure. But I feel like there's the immediate interest of being able to see your kids versus the long-term interest of making sure that how you go about doing that doesn't impact your ability to defend yourself against these charges.
Yeah.
Particularly because in a lot of cases, I mean, you can't, not criminal court. In criminal court, you have to admit facts and it has to be voluntary and all of these things. But I'm 100% confident that there have been people who have pled guilty just because it's the easiest thing to do to get them what they need, which is not jail time or not this or not that. And part of my job is to make sure that that doesn't happen, for sure. But I imagine a similar thing would happen in family court sometimes where they're like, yeah, I'll do whatever I have to do, whether I agree or not.
Yep.
I'll say what I have to say because this is the outcome I want. And that's like those competing interests is where I get very concerned when people come in. They're like, all I care about is this.
Yeah.
It makes it very hard for me to do my
Then
job.
That's when you should talk to both, like have your counsel to communicate and come up with a strategy that works together, right, in conjunction. Because if the main goal is to make sure we get to see the kids, then we got to set something up so they have at least some access, right? Maybe it is supervised in the meantime, where we just say, okay, take the supervised access because that's what's going to be happening in family law, and then we'll deal with the criminal until that's done. But at least you have that access. But if you want to be more aggressive on getting that lifted and move forward on the parenting side, you might want to have a bit of a different strategy and talk with the criminal lawyer about, no, I'm going to do this, and maybe we can structure it in a certain way.
So you have collaborated with defense counsel
Yes,
before
I have,
then?
yeah.
And as it went smoothly, like you guys have been able to find, I'm just saying, I'm sure it would be fine if I spoke with you, but it's just
defense
like,
lawyers are difficult to deal with. Is that what you're suggesting?
no. I think they're actually very easy to do.
The ones I've dealt with have been great. So,
Yeah.
I haven't worked with
wait till
Kate,
you
though.
wait till you deal with her.
That's not true. Extremely reasonable.
Well, thank you very much, Matt, for coming back. It definitely wasn't going to be a one and done type of situation. In
All
fact,
right.
we're going to have you on again
I feel
for
like we've got
another
much
episode.
more to talk about.
Yeah,
so,
absolutely. Yeah, no, it's a great conversation, and glad you could be educating our viewers on these important topics.
Well, happy to help and happy to be here. So.
I'll try to stay more calm next time.